Hi guys, I hope you all are doing well. This is Sejpreet Kaur and you're watching Legal Bites. In today's video, we'll be looking at the legal maxim Amicus Curiae. In this video, I'll be covering the meaning and origin of the maxim, the application of the maxim, and a few important case laws to understand the maxim better. So let's get right into the video. Let's start with the meaning and origin of the maxim Amicus Curiae. So Amicus Curiae is a legal maxim of Latin origin. Now to understand the meaning, we'll break down the maxim into two words, which is amicus and curiae. So amicus means friend and curiae means court in Latin. And hence the term Amicus Curiae literally means friend of the court. So now that we know the meaning of the maxim Amicus Curiae, let's understand it from a legal perspective. So Amicus Curiae means a person who assists and recommends the court on matters of legal importance, and that is why they are known as the friend of the court. Some of the characteristics of Amicus Curiae are as follows. 1. He or she has no direct interest in the decision of the case law. 2. He or she is not a party to the suit and is a third person. 3. His or her opinion is not in favor of any of the parties. That means it is unbiased opinion and is only in the favor of society at large. Now let's move on and discuss the application of the maxim Amicus Curiae. So our courts in certain areas find it difficult to come to a conclusion, and hence they invite amicus briefs from the experts in those areas of law. Or some experts might even offer to help voluntarily. Now after the court goes through these briefs, it is up to the discretion of the court whether to consider them or not. Next up are the case laws. The first case is that of Allen versus Sir Alfred and Sons Limited. It was in this case that Salmon L.J. observed that the role of amicus curiae is to assist the court and expound on the law impartially, and if any of the parties to the suit is unrepresented, to represent, advance and frame legal arguments on behalf of that party. This is done in order to ensure the accuracy of the decision and to make sure that both the parties to the suit are adequately represented in the court of law. Next is the case of Anokilal versus State of Madhya Pradesh. It was in this case that court laid down certain guidelines in respect of amicus curiae. The first is that in cases of death and life sentences, the advocates with a minimum of 10 years of practice can be appointed as amicus curiae. Second is that if any person is appointed as amicus curiae, he or she must be given a reasonable amount of time to understand the case scenario. Third is that if a person is appointed as the amicus curiae or the party representing the accused, he or she is permitted to have meetings with the accused. So this is it for today's video. Thank you so much for watching our video. Please do not forget to like, share and subscribe to our YouTube channel. Additionally, there is an article on the same maxim, the link to which can be found in the description box below. Thank you.